Hello viewers, this is Aravindar Annai Arul channel welcomes you. How are you? In this video we have to see, while expecting his leader to be honest, voter should be honest. Corrupt voter cannot expect his leader to be honest. Observed the Telangana High Court. For more information, we shall move to the inside the video. I request to all the viewers to kindly watch this small video in full. Now we shall move to inside the video. Hello viewers, this title of the video is observed by the Telangana High Court while dismissing the revision petition filed by A Revanth Reddy, member of Telangana Legislative Assembly, challenging the jurisdiction of the trial court to try proceedings in cash for vote scam case pending before the Special Anti-Corruption Bureau ACB court. A single judge bench comprising of Justice K. Leshman, while analyzing the importance of voting under the constitutional scheme, observed thus: secret ballot system was also introduced to maintain the secrecy of the vote. It is also relevant to note that the apex court is one of the judgments held that secrecy of ballot is sacrosanct. It is also relevant to note that while expecting his leader to be honest, voter should be honest. A corrupt voter cannot expect his leader to be honest. The case pertains to MLC elections for Legislative Council, wherein Revanth was accused of offering rupees Crore bribe to then nominated MLA Elvis Stephenson for securing his vote in favor of TDM party in the elections. Revanth was accused of offences under Section 12 of Prevention of Corruption Act 1988 and Section 120B read with Section 34 Indian Penal Code 1860. It was a case of the petitioner that the provision of the Prevention of Corruption Act are wholly inapplicable as the field of electoral malpractices is covered under Chapter 9th A of IPC. Therefore, ACB did not have the jurisdiction to register FIR in the case. It was thus submitted that offering bribe does not attract the offence for punishment under Section 12 of Prevention of Corruption Act. Furthermore, submitting that right to vote of an elector is a statutory right, it was submitted by the petitioner that an MLA exercising such a right is acting in his capacity as an elector and cannot be conflated with the exercise of his public duties in his capacity as a public servant, offences of which are governed by IPC but not the PC Act. Therefore, it was the case of petitioner that the ACB had erroneously assumed the jurisdiction to investigate into election related offences and filed the charge sheet erroneously. Analyzing the fact of the case, the court relied upon relevant extracts of the Constitutional Assembly debates and the views of the drafting committee while introducing voting and citizenship in the Constitution. Quoting Dr. B.R. Ambedkar, H.V. Kamath and Alade Kuppu Swami Iyer, the court opined that Dr. B.R. Ambedkar had voiced that ultimately democratic government was inseparable from the right to vote, and it was voting that would prove to be the one of the harbinger of political education. Observing that while expecting his leader to be honest, voter should be honest, the court observed that the ACP officials, after conducting investigation, laid down charge sheet against the petitioner and other accused persons involved in the case. In the aspect of determining the jurisdictional fact, the court was of the view thus: a jurisdictional fact is one on existence of non-existence of which depends assumption or refusal to assume jurisdiction by a court. It is explained as a fact which must exist before the court can properly assume jurisdictions in respect of subject matter which the statute does not confer on it, and if by deciding erroneously the fact on which jurisdiction depends the court or tribunal exercises the jurisdiction, then the order is violated. Thus, it is clear that the existence of jurisdictional fact is sine qua non for exercise of power. Furthermore, on the aspect of Section 12 of the Prevention of Corruption Act, the court observed that the act was intended to make the existing anti-corruption law more effective by widening the coverage and strengthening the provisions of the act. It is the mens rea of the bribe giver that has to be considered in a case, and it should be sufficient to render him liable if he is object in bribing or attempting to bribe the public servant was to induce the public servant to do an official act in exercise of his official function. With the aforesaid observations, the court observed that there is prima facie material to frame charge under Section 12 of the PC Act and other section of IPC, noting that the discharge petitions filed by other co-accused persons were dismissed by the court. It was observed thus the petitioner herein failed to make out any case to interfere with the challenged order by this court in exercise of its revisional jurisdiction under Section 397 and 401 of CRPC. Therefore, the present criminal revision case is liable to be dismissed. Hello viewers, from this video you learned the Telangana High Court observation: while expecting his leader to be honest, a voter should be honest. A corrupt voter cannot expect his leader to be honest. If you are liking this video, means kindly press the like button as well as share to your friends and relatives. I kindly request to all the viewers to subscribe this Aravindar Annai Arul channel. Thank you for watching this entire video in full. Thank you very much once again.